asking you guys nicely to put the phone down?
Why are you approaching
If not, then I'm going to have to detain you. Well, you guys are detained.
What are you approaching us for?
Because you guys were at the gas station for an abnormal amount of time, then you guys saw me, and then you pulled off over into the Citizen 33 parking lot, and then you guys switched drivers.
What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. If you have any interest whatsoever in constitutional law or the history of the Fourth Amendment jurisprudence or anything like that, you've probably heard of the case of Terry versus Ohio. But have you ever actually heard what the case was about or why it's so universally mentioned in the context of the Fourth Amendment jurisprudence? Well, that is the subject of our next two videos, which I'll release as a series. Part 1 will focus on the Terry stop, and Part 2 will focus on the Terry frisk. Now, our example video today comes to us out of Detain County, Idaho, and it was first published by the YouTube channel Peel Back the Law. The video depicts an interaction a couple had with some Detain County deputies when the sheriff's deputies detained the couple for nearly 2 hours, waiting for a canine to come and sweep their vehicle for the purposes of detecting drugs. Now, when I saw this video, I thought it would be a perfect segue to discuss Terry and its impact on modern policing. Now, I have made substantial edits to the video, but I'd suggest to you that you should go over to Peel Back the Law's channel, watch the video in its entirety, and give them credit for sharing it. Without further ado, let's get into it.
I'm inside. Hey, here to talk to you. So you were at the gas station for a really long time, and then pulled over, switched drivers. So why are you avoiding us?
Not at all. Actually, you just went down the wrong road because I was going to go to the thrift store.
The thrift store over by Citizen 33?
Yeah.
It's not even close.
Well, I'm not from here, so like, it wasn't a big deal. Like, it wasn't.
You are though. You've been around here before.
It was. I just turned too soon.
Gotcha.
Yeah.
So the thrift store is like half a block away from where you turned down, and then you guys switched drivers. Why'd you switch drivers? Does he have warrants?
No.
Who is he?
My boyfriend.
Okay.
Ben.
Ben what?
Crazy.
Crazy? Okay. Is there anything in the car that you guys are hiding?
No.
Do you mind if I check?
You can do whatever you need to do.
Okay. 2722, have him step out. Teton 22, and then I can start search.
Actually, you know what? You have to call my lawyer.
Okay.
You have to call my lawyer.
Sounds good. You can't go back into that car though. The post office. And Teton 22, can you get a K9 around? Hey guys, so while you're here, I'm gonna have you put your phones right here. You step out of the vehicle, please.
I'm not giving you permission to touch my car, actually.
That's okay.
Yeah.
So you're gonna put your phone down here though, and he needs to get out.
I'm calling my lawyer.
I'm not gonna put my phone down.
I'm not doing
Call my
anything.
lawyers.
Actually,
You guys can put the phone down for right now.
I'm calling my lawyer
Call
right
my
now.
lawyer. Thank you very much.
Okay, that's
Because I
fine.
have that right. Thank
You don't. Asking you guys nicely to put the phone down.
Why are you approaching
If
us,
not,
first
then I'm
of
gonna
all?
have to detain you.
What are
Well, you guys are detained.
What are you approaching us for?
Because you guys were at the gas station for an abnormal amount of time, then you guys saw me, and then you pulled off over into the Citizen 33 parking lot, and then you guys switched drivers. Okay, I've asked you guys nicely to put the phones down.
One moment.
We have a right.
That's
We have a right.
Speak to my lawyer.
right.
Speak to our lawyers,
You guys
right?
do. Not
you
at
cannot
right this
just-
moment.
That we were at the gas station for
You guys were at the gas station for an
pulled
abnormal
over.
amount of time.
Okay.
You guys saw me. You guys pulled over,
Actually,
switched
you
drivers.
pulled out before we pulled over.
No.
Yeah, you did, actually, because I saw you in the back mirror when we were in there.
Okay, we can argue about that in court.
We don't have
That
to
being
argue about it.
said.
I know the facts.
Okay.
So they're bringing, there's Sean, they're saying we're being detained, and they're gonna bring the drug dog to our vehicle.
Sergeant Allison, both of you sit on the curb right now.
I'm sorry?
Sit on the
We don't have a right to say.
I can, we are detaining you. Sit on the
We're
curb.
not, you can't detain us, this is our lawyer. You talk to him, not
Sir?
us.
All right, sit on the curb or you're under arrest for resisting.
I have done nothing.
Sit on the curb.
What have I done?
Sir, sit on the curb.
Can you tell me what law I've broken?
Sir, sit on the curb.
Will this be over?
I'm not gonna.
Sit on the curb.
What have we done wrong?
We are calling for a canine. Sit
I
on
don't
the
care
curb.
about the canine. There's a bot.
Sir, I'm ordering you to sit on the curb.
Ordering me.
Yes.
Can you please
We're not in the military. I was in the military, but thank you very much. Okay,
You're under
okay.
arrest for obstructing.
So as you can see, this female deputy, who is identified as Deputy Ashley Hayes from the Teton County Sheriff's Department, has approached the female for what I would call at this point a consensual encounter. But what we saw right before she actually makes contact was that she already called a canine, which she did by whispering into her radio from inside the post office. Shortly after she made that radio contact, she made contact with the female. She waited for the female to finish her business at the post office, and then she confronted her outside the post office lobby and began basically accusing her of avoiding the police. So, as you could hear, her suspicion is based on the deputy's observation that this couple was at a gas station for what they referred to as an abnormal amount of time. And they further postulated that these people were avoiding the police by stopping to switch drivers. So the question you might have is, under what circumstance can a police officer lawfully detain a person for investigation? And more specifically, is general criminal activity enough, or do they have to articulate a specific crime? Moreover, do they have to articulate that crime to the person they're detaining? For all of that, we will go to none other than the case I referred to at the beginning of this video, Terry versus Ohio from 1968. What I didn't realize when I set out to do this series is that I'd be filming it on June 10th, which just so happens to be the day that this case was decided in 1968. Now, I don't celebrate the decision because I think it's a bad one, and I think that even if the intentions of the justices were good when they decided the case, what it has become is basically an out-of-control monster. But I have to admit that it is kind of cool that we're talking about it on the exact date it was decided 56 years ago. So we're going to go all the way back in time to 1963. This is some 5 years before the case was decided. So the actual incident happened in 63. And here's the gist of what the case is about. The setting is Cleveland, Ohio. The area is the downtown district of Cleveland, Ohio. We have Euclid Avenue and Huron Street. And they kind of come together in this little triangle. So you got Huron that runs up this way, and then you got Euclid Avenue that goes this way. And then there's like this point that forms like the triangle here. Martin McFadden is a detective, and at that time he had like 38 or 39 years on the Cleveland Police Department. He was assigned to patrol the downtown area, and his specialty is catching shoplifters and pickpockets. Now it's around 2:30 in the afternoon, and McFadden sees two colored guys, as he describes them. According to his police report, he first notices them standing at the corner of Huron Road and Euclid Avenue. Specifically, these guys made multiple trips up and down the sidewalk, and each time they walked up and back, they stopped to look in the same store window, and then they would come together and they would talk. So McFadden testified that he observed this for 10 to 12 minutes. Each time after they would go and look in the windows up and back, they'd join one another on the corner and have a brief discussion. Then a third guy came up and met with them. McFadden watched them, and he took the position that they were casing the stores for a potential robbery. Being that he thought they might be planning a robbery, he felt like they potentially had weapons on them to accomplish the robbery, and so he decided to confront them. He ends up catching up with the three guys in front of a men's clothing store called Zucker's, which they called a haberdashery. So if you happen to listen to the oral arguments, which I'll link in the description, they refer to Zucker's as a haberdashery. That's just a men's clothing store. He asked them their names, and they sort of began mumbling. Now the first guy, John Terry, who's the subject of the name and the opinion, McFadden grabs him, he spins him around, and he kind of holds him between the police officer and the other two subjects, and he begins patting him down. During the frisk of the outside clothing of Terry, he felt what he testified that he thought was a gun, and then he went inside the top coat and removed a .38 caliber automatic Beretta pistol. He similarly moved on to Richard Chilton, which was the second guy, and he felt what he thought was a gun on him in his outer clothing, and he went inside the top coat pocket, and he subsequently removed a .38 caliber revolver from Chilton. The third man was named Carl Katz. He was also patted down on the outside of his clothing. He had no weapons, and so he was subsequently released. Now each of the men had their outer clothing patted down for weapons, and only if McFadden felt a weapon did he go inside the clothing to retrieve it. Chilton and Terry were charged with with carrying concealed weapons, and no charges were brought against Katz. Now, interestingly, Terry and Richard Chilton were both represented by the same attorney, Lewis Stokes. However, Richard Chilton was killed in a convenience store robbery before the case made it to the Supreme Court. So that's why Terry is the name attached to the case. This case also has some pretty cool and significant history attached to it because it was the first time that an African-American lawyer was both arguing a case to the Supreme Court and hearing a case as a justice for the Supreme Court. So the attorney that was arguing the case was Lewis Stokes, who went on to serve like 30 years in Congress. He was a very, very famous civil rights activist and congressman from Cleveland, Ohio. He was the lawyer that was representing Terry, and the African American on the Supreme Court was, of course, Thurgood Marshall. And so for the first time in history, you had two black men who were attorneys who were dealing with a case on the Supreme Court of the United States. But what was the actual meaning or significance of the Terry case? Well, first, the court sought to determine whether the men were actually seized under the meaning of the Fourth Amendment. And they held that whenever a police officer accosts an individual and restrains his freedom to walk away, he has seized that person. So now that we understand that the Fourth Amendment applies because we have a seizure, the court then looked at trying to determine whether the seizure was constitutional under the Fourth Amendment. Now you have to keep in mind what the Fourth Amendment looked like in 1963. We were fresh off the Mapp versus Ohio case, where the Supreme Court first sort of conceptualized the application of the exclusionary rule being applied to the states through the 14th Amendment. And the court held that evidence obtained in violation of the Fourth Amendment could not be used in a criminal prosecution. And the law of the land up to this point was that the police could not seize a person absent probable cause to place that person under arrest for a crime. In other words, prior to Terry, the police had to do their investigation, and then if they were able to establish probable cause, they could make an arrest if it was something that they could arrest for without a warrant, or they could submit their findings to a judge and they could get a warrant and then they could go arrest. But without probable cause, they couldn't seize a person. This case changed all of that, and it's why I believe, as so many others do, that Terry versus Ohio was the beginning of the erosion of the Fourth Amendment protections that we're supposed to enjoy. The court in Terry basically said that it was okay for the police to detain someone for a brief period of time for investigation when they didn't have facts sufficient to establish probable cause for an arrest, so long as the police officer was able to point to specific and articulable facts, which, taken together with rational inferences from those facts, reasonably warranted an intrusion into the personal liberty of the person being stopped. And they also said that in determining whether the officer acted reasonably in such circumstances, due weight must be given not to his inchoate or unparticularized suspicion or hunch, but to the specific reasonable inferences which he is entitled to draw from the facts in light of his experience. So that would be different for a police officer like Martin McFadden with 38 or 39 years of experience than it would with, say, a 2-year patrol officer. Because again, the reasonable inferences have to be drawn in light of the experience of the police officer and based on the facts known to the police officer at the time. As broad as this case has been applied, what the court actually said it was supposed to be doing in the holding in Terry was to answer the very narrow question of whether it was always unreasonable for a police officer to pat somebody down in a stop and frisk. This case was never really designed to be like a landmark case that would change everything. And I would argue that the Supreme Court had a foreseeability problem in not realizing that this would take its own life. But the court basically said in its final holding, and this is a quote, "We merely hold today that where a police officer observes unusual conduct which leads him reasonably to conclude in light of his experience that criminal activity may be afoot, and that the persons with whom he is dealing may be armed and presently dangerous, where in the course of investigating this behavior, he identifies himself as a policeman and makes reasonable inquiries, and where nothing in the initial stages of the encounter serves to dispel his reasonable fear for his own or other safety, he is entitled, for the protection of himself and others in the area, to conduct a carefully limited search of the outer clothing of such persons in an attempt to discover weapons which might be used to assault him." Now that was the actual holding in Terry versus Ohio, but again, the court bifurcated a stop and the pat down into two separate sections in the course of laying out their opinion. Because what they said was that the frisk could not be constitutional unless the stop started constitutionally. And so they went through and they basically created two separate doctrines and sets of rules. One for a Terry stop and one for a Terry frisk. And that's the reason that the first part of this video is about the Terry stop, and the next video will be about the Terry frisk for weapons. Now let's apply those facts to the case that we started this video with. We have a police officer following a lady from a gas station into a post office. Now they don't have any reason to conduct a traffic stop, so there are no traffic infractions. Keep in mind, if they had reasonable articulable suspicion of a crime, they could have stopped the car at any time. You can stop someone driving a car for a regular Terry stop, just as you could if they were walking. You don't actually need a traffic violation just because a person is driving a car. You can make a Terry stop based on reasonable articulable suspicion and treat it just the same as you would if they were just walking down the street. So you have to remember that at least on its face, their conduct suggests that they didn't feel like they had justification to stop the couple while they were driving. So no reasonable articulable suspicion at the time that they encountered the couple. They end up deciding to detain them when basically the only thing that changed was that the couple first gave their consent and then revoked the consent. They had already called for a canine, and then they decided to detain them for 90 minutes waiting for a canine after the lady revoked her consent to search the vehicle. So remember, the totality of the circumstances here are that the couple was at the gas station for an abnormal amount of time. They switched drivers, which made the police think that they were trying to avoid them, and that's pretty much all we have. Now, one of the common misconceptions as it relates to Terry, and one of the questions that I asked in the beginning part of this video, is whether or not the police have to tell people what crime they suspect them of committing, or whether they have to lay out a particular crime that they're suspicious of. You hear a lot of times auditors will be like, well, what crime do you suspect me of committing? Or people that are trying to deny ID will say, well, what crime do you suspect me of committing? The police don't actually have to tell people what crime they suspect them of committing. They don't actually have to tell them anything. Somewhere along the way, though, they will have to articulate this stuff to a court of law if they decide to charge somebody or if they get sued. But remember that the holding in Terry was that the officer had reasonable articulable suspicion that criminal activity is afoot. So it's very broad. But remember that in addition to the suspicion, the court attached this rational inferences language to what is required of the police officer. So while it is very broad, we're going to take a look at some rational inferences examples and see how that looks. If you look at the court's summary of the McFadden observations and how they came together to change what could be described as innocent conduct in the abstract and convert it into reasonable articulable suspicion in the eyes of the court when taken as a whole, you'll see that the circumstances here are drastically different than the ones in Terry. In Terry, the court said of McFadden's observations, it summarized it, and it said, quote, he had observed Terry, Chilton, and Katz go through a series of acts, each of them perhaps innocent in itself, but which taken together warranted further investigation. There is nothing unusual in two men standing together on a street corner, perhaps waiting for someone. Nor is there anything suspicious about people in such circumstances strolling up and down the street, singly or in pairs. Store windows, moreover, are made to be looked in. But the story is quite different where, as here, two men hover about a street corner for an extended period of time, at the end of which it becomes apparent that they are not waiting for anyone or anything, where these men pace alternately along an identical route, pausing to stare in the same store window roughly 24 times, where each completion of this route is followed immediately by a conference between the two men on the corner, where they are joined in one of these conferences by a third man who leaves swiftly, and where the two men finally follow the third and rejoin him a couple of blocks away. It would have been poor police work indeed for an officer of 30 years experience in the detection of thievery from stores in this same neighborhood to have failed to investigate this behavior further. That's what the court said, and how they brought all of McFadden's observations together to create reasonable articulable suspicion because of the rational inferences or the scope of what he suspected they were up to. So you can see that taken all together, these guys were probably up to something. And the rational inference piece that the court was trying to talk about was that you notice how all of this kind of ties together in scope and leans towards a particular type of crime: burglary, robbery, theft, etc. So that's what I mean by scope, and that's what the court meant by rational inferences based on what they were doing and what he thought. In other words, rational inferences and scope kind of lend themselves to the definition of a particular crime that he suspected them of committing, or a block of types of crimes that he suspected of committing. Now, let's compare that to the video we started with. The first observation is this female deputy and a couple officers observed a couple at a gas station for what the officers thought was an abnormal amount of time. Observation number 2, the deputies said that they stopped and switched drivers, and that's it. So we seem to have a rational inference or scope problem here. And here's what I mean. The officer said that they were at the gas station for an abnormal amount of time. That could mean that the officers thought they were casing the gas station. But what the officers did in response to their hunch or suspicion was that they called a deputy with a canine. Now that would lend itself more to the idea that the gas station in question is probably a high drug area, and the deputies thought that these people were there to buy or sell drugs. The officer also indicated that she thought that they were avoiding the police by switching drivers. Well, the rational inferences or the scope of avoiding officers has a pretty limited application as well. Either you avoid the police because you have warrants and you know as a driver you have to identify, but as a passenger you don't. But let's be honest, I mean, police officers always make the passenger identify, even though they're not supposed to be able to. Or you realize you're being followed and you have a suspended or no driver's license, so you switch drivers. Or you're DUI and you switch drivers. If you're involved in drug activity, you're jointly involved in it, whether you're the driver or the passenger. So switching drivers doesn't make you more or less culpable, because we have tons of cases out there that suggest that anything found in the car is constructively possessed by everybody in the car, if that's the way the state wants to proceed. None of the rational inferences attached to switching drivers and avoiding the police are related to drug activity. So it's clear that the criminal activity that the police suspect is related to drugs, but they can't seem to cite any specific or particular facts with the rational inferences related to the behavior of this couple that would lend itself to the idea that they're involved in drug activity. All they can cite is loitering at a gas station. Well, a problem with that is that the suspicion should be immediately dispelled by the explanation that they gave. They were paying customers of the gas station who had just made a purchase of lottery tickets and were doing what a lot of other people do, sitting in the parking lot, scratching off their tickets to see if they won anything. And apparently after they realized they didn't win, they left. So in my opinion, there really isn't anything else that would lend itself to reasonable articulable suspicion here. This was an egregiously unlawful detention, because altogether these people were detained for like 2 hours while they waited for a dog, which, by the way, didn't alert to anything. The male ended up being arrested for refusing to comply with an order that was probably unlawful due to the lack of reasonable articulable suspicion to justify the detention in the first place. So you have a host of Fourth Amendment violations here that are probably ripe for a lawsuit. This case provides the very definition of an unparticularized hunch as described in Terry, and exactly what the court said was not enough to support a lawful investigatory detention under the Fourth Amendment. So based on the way I see this case, there was no lawful basis for the detention. Now, in closing, I want to set the stage for part 2 of this series. So far, we've talked about the Terry stop, but this case was really more about the Terry frisk, and that's why you'll hear people, when they quote Terry, they try to say, well, Terry only applies to situations where there was weapons. That's not what the opinion in Terry says. The opinion is bifurcated in theory about the fact that the stop was separate from the frisk. And all it takes is somebody willing to put in an hour's worth of reading to sit down and read it to understand that. But most people don't. They just take what other people say and then they make an argument, which is why they have a very superficial understanding of case law in the first place. But the court made sure to articulate that it was the stop in Terry that had to comply with the Fourth Amendment before the analysis for the frisk could begin. So here's a hint about what's coming next. Whether you realize it or not, Terry's impact had much less to do with investigatory detentions than it did with carving a new rubric of police activity that would quickly evolve into much more than the Terry court ever envisioned or intended. Terry marked the first time that the disease that we all know as officer safety was given oxygen in a Supreme Court opinion. The court actually said, as it related to the frisk, that the sole justification of the search in the present situation is the protection of the police officer and others nearby, and it must therefore be confined in scope to an intrusion reasonably designed to discover guns, knives, clubs, or other hidden instruments for the assault of the police officer. Regardless of what anyone would have you believe, if you read the discussion of the case by the court, and if you listen to the oral arguments, which again I've linked in the description, and it'll be in the description of the next video, at the heart of the Terry versus Ohio decision was whether McFadden had a right under the auspices of officer safety to stop and frisk these guys. The entire argument made by the state was that McFadden had a duty to investigate crime, and as such, he had a right to make sure the people he was confronting, if he believed they were about to embark on a violent crime, did not have weapons that could harm him. Thus, the pat down. And so part 2 of this series will focus on the Terry frisk for weapons and the monster of the doctrine of officer safety that was created, probably unintentionally, by this case. That's all for this one, guys. Thanks for watching. Please remember to like and subscribe and leave me a comment. Watch some other videos on the channel and leave me a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.